Hello, and welcome to the newest edition of Nelson Mullins' 2021 Education Law Webinar Series. Thank you for joining us today. My name is Dan Cohen, and I'm a partner on Nelson Mullins' Education Law team. Nelson Mullins is an AmLaw 100 law firm with about 800 attorneys and policy advisors across 25 offices in 11 states plus Washington, D.C. Among other practices, we have a dedicated team of attorneys focused on serving all legal needs of education institutions, including in the areas of labor and employment, healthcare and issues affecting academic medical programs, construction and real estate, intellectual property, privacy and information security, and unique issues affecting education institutions like student and faculty discipline, sexual misconduct, and athletics. We host free monthly webinars addressing legal topics across these areas for education institutions, and sometimes more frequently as issues arise. Please feel free to contact one of our education lawyers if you have any questions about our webinars or any other issue affecting education institutions. And if you have ideas for future webinar topics, please feel free to reach out. Let us know via the question or feedback form during or after today's webinar. Today, Nina Gupta, Brandon Moulard, and Jeff Daniel are going to talk about remote work policies after COVID. Post-COVID, colleges, universities, and school districts must decide whether to allow their employees to continue working remotely or require them to return to the office full-time. This webinar will address the challenges of long-term remote work policies. Nina Gupta focuses her practice on education law, representing public and private educational entities, vendors, and professionals. She is the current general counsel to Atlanta Public Schools, which is a large urban school district serving over 50,000 students. She works directly with governing boards and education leaders to promote effective policy development and compliance, and she focuses her practice on providing legal advice to education clients in the areas of disability and discrimination law, employment matters, Title IX, regulatory compliance, and litigation. Brandon Moulard is a litigation partner in Nelson Mullins' Atlanta office. He has represented numerous public and private educational organizations, including K-12 public school districts, charter schools, private schools, colleges, and universities, in a broad range of federal and state litigation, including civil rights lawsuits, Title IX, employment, personal injury suits, and special education disputes. He also conducts investigations for colleges and schools related to potential claims. Last, Jeff Daniel is another member of our education team. Jeff focuses on litigation, Title IX investigations, and regulatory compliance issues. He has extensive experience representing clients in all phases of litigation, including alternative dispute resolution, preliminary injunctions and TROs, class certification matters, dispositive motions, discovery, trial, and appeals. He also represents education institutions during internal and government investigations and advises them on developing policies, procedures, and training guidelines to comply with Title IX. With that, I will turn it over to Nina, Brandon, and Jeff.
All right, thank you, Dan. And good afternoon, everyone, or depending on where you are, good morning. And thank you for all taking time out of your day to attend this webinar. The topic of remote work is top of mind for employers across all industries, including colleges, universities, public school districts, and others in the education sphere. Historically, most employers' expectations were that employees were to spend working hours in the office or on campus or their school building, as it were. And remote work was considered mainly to be an emergency measure or as a means to accommodate qualified individuals with disabilities under the Americans with Disabilities Act. But of course, COVID changed all that. Your college or your school district has probably had to survive for a year with a workforce that was predominantly, if not entirely, remote-based. COVID has forced employers to reevaluate their attitudes toward remote work and reconceptualize how tasks get done outside of a traditional workplace setting. But in the last couple of months, COVID cases have trended downward in most states, and vaccine access has expanded. The pandemic is not over yet, but for the first time in over a year, there was a collective glimmer of hope that we're turning the corner and finally entering a post-pandemic reality. The most prudent colleges, universities, and school districts are now considering what role they want remote work to play when it is no longer necessitated by a global pandemic. Will remote work return to its traditional status as an emergency measure or individualized accommodation? Or will it become an institutionalized component of your campus's workplace? There are plenty of reasons why you, as employers, might want to keep remote work as an option. To begin with, your employees probably want it. In January of this year, PricewaterhouseCoopers published the results of a survey of 133 executives and 1,200 office workers across various sectors. And what they found was that over half of employees, 55%, said that they prefer to be remote at least 3 days a week, even after concerns about the pandemic disappear. And 29%, nearly 1/3 of those surveyed, want to work remotely 5 days a week after the pandemic. And to their credit, 83% of employers said that the shift to remote work has been successful for their company. And indeed, remote working arrangements can have benefits for employers. They can provide flexibility for your workforce. They can decrease overhead and operating expenses, especially if you operate a large office. And they can help employers in the education sphere draw on a broader pool of talent since they're no longer limited to a specific geographical area. Whatever your college or school district decides about the role that remote work will play after the pandemic, it's critical that you have a clear written policy on remote work in place. A well-written remote work policy will communicate to your employees what your expectations are in terms of time spent in the office. And clear policies can help alleviate accusations that your campus's remote work policy was offered in an unequal or discriminatory fashion. Those are the kinds of allegations that can lead to grievances or EEOC charges or even costly lawsuits. So if you have an existing remote work policy, now is the time to ask whether it needs to be revised or supplemented. And if you don't have one and your campus has just been winging it for a year, it's never too late to develop a policy, and you need one. If you take away anything from today's webinar, it's that you need a written policy and it needs to be clear. The purpose of this webinar is to help you develop your remote work policy. Our goal is to give you guidance, or at least have you start thinking about several foundational questions that your school must answer when considering the future of remote work at your college or school district. For instance, have you considered whether long-term remote work is even feasible for your workplace? What duties are conducive to working remotely, and which ones need to be performed on campus? Do you have clearly defined job descriptions that identify the essential functions of all employees' jobs? And do those descriptions spell out which duties can be performed remotely and which cannot? If you're not going to extend a remote working option after the pandemic to some of your employees, do you know how you will define the non-discriminatory reason why some employees may work remotely but others may not? Are you going to allow employees to work from other states? And if so, are you prepared to handle the tax and benefit obligations that hinge on employees' locations? Do you have the HR staff and the legal support to handle complex multi-state tax questions? Do you have the means to monitor working hours to make sure you're paying non-exempt employees overtime and complying with federal and state wage and hour laws? And what resources, policies, and trainings do you have in place to provide to your employees to promote data privacy and information security? Those are some of the questions that we hope to answer today. And with that, and to kick things off, I'll turn it over to my colleague Nina Gupta to talk about feasibility and workplace culture.
Thank you, Brandon. As your institution is considering remote work for the future, you need to consider two threshold questions before moving forward. First, is remote work even feasible on a technical level? And second, what impact is remote work going to have on your workplace culture after these concerns around the pandemic are over? When we look at feasibility, we're talking about the real nuts and bolts of what a job entails and what remote work would require. First, schools and universities need to decide, is remote work going to be an emergency option only, like for weather events or, God forbid, another pandemic? Or is this going to be a standard option where employees can elect to work remotely for a given number of days per week or hours per week, or even permanently? Also, will those decisions about which employees can work remotely be made on a centralized basis by your HR staff? Of course, these decisions are going to need to be centralized to some degree. Schools and universities need to take this opportunity to review their job descriptions and be very thoughtful and deliberate about what the essential functions are of a job and what really can be done remotely and what cannot be done remotely. Some things are obvious, some not so. For instance, transportation work, food service work do not lend themselves to remote work settings, so these job functions may not be eligible at all. Likewise, your institution may determine that offering students an in-person learning experience is an essential function for faculty members or certain types of faculty members. But for those job categories that could be amenable to remote work, your institution needs to decide which individual employees are eligible and what their remote work schedules will be. For instance, is the school's HR department going to decide which employees are eligible across the institution and how long they can work remotely and under what circumstances? Or will departmental leaders be given guidelines and the authority to determine remote work arrangements within their departments? Additionally, schools and colleges need to look at the resources needed to implement remote work. First, you've got to have the technological capabilities to accommodate it. And we've all spent the last year living a real life simulation of what those technological capabilities might need to be. Additionally, your employees may need access to certain equipment to do their jobs. Now, certain equipment is obvious. They might need a laptop. They might need a hotspot or reliable internet connectivity. But some of our employees need access to more specialized equipment. And your institution is going to need to decide whether or not that equipment can reasonably be made available in a remote setting from wherever they might be working from. Finally, your institution needs to have access to tax and legal professionals that can guide your school through complex compliance issues related to remote work. And in a moment, Jeff and Brandon are going to get to some of those legal compliance issues and tax compliance issues. But let's assume that you've worked through all of these feasibility issues. You also need to consider how remote work is going to impact your workplace culture after this pandemic is over. How is your culture going to be affected with less in-person interaction among colleagues if in-person interaction had been the norm? This is a great opportunity to reflect on the past year since, like I said, we have all lived through a real-life example. What worked and what didn't? If schools are going to offer remote work as a possibility, you should also consider setting professional expectations for employees who are on remote work. For instance, if they work in a central office support role for faculty, you can set an expectation that they need to route their office phone numbers to their remote work site so they remain fully available to faculty during work hours and responsive to emails. Similarly, if you haven't already done so, consider some professional etiquette expectations for remote meetings. For instance, cameras need to be on, employees need to be in professional attire, they need to be logged in from a quiet, distraction-free space. Simply put, remote work should not change the performance expectations for your employees, and schools should retain the authority to change remote work requirements at any time to meet the needs of the institution and to keep a strong workplace culture. Also consider how you're going to handle performance assessments and workplace morale when some of your workforce is remote and some is in person. So many schools this past year especially have extended a lot of grace in evaluating their employees since remote work has been done very much on an emergency basis and we were all learning together. But if remote work is going to be an ongoing and standard option, we have got to do a better job of having a meaningful assessment standard and platform for our employees, regardless of what their work looks like. Likewise, you can anticipate that there will be some morale issues when only some of your workforce has the opportunity to work remotely, and you can and should pay attention to those workplace morale issues, including perceptions about who is more productive, who has it quote unquote easier, and the like. Establish up front that remote work is a privilege and not a right that comes with real, meaningful, and enforced expectations for performance. Now, it may seem that offering remote work as an option at any level is going to be more trouble than it's worth. As Brandon mentioned, though, remote work seems to be very popular with employees, and it seems to have been successful in the eyes of employers as well. So not offering remote work as an option may put your school at a disadvantage when it comes to recruiting talent. Given that, you'll probably find yourself in the place of needing to work through these issues, and it's generally better to do that now when you have the luxury of time to be thoughtful and deliberate. Next, Jeff is going to lead you through some of the tax implications of remote work.
Thank you, Nina. And can you go to the next slide, please, Brandon? Thank you. I'm not a tax lawyer, but our firm has a robust tax practice, including many lawyers who focus on state and local tax. My goal today is not to provide you with a comprehensive understanding of what your tax obligations are in a given scenario. It is simply to sensitize you to some of the ways in which remote work may unexpectedly impact your tax liabilities and obligations as an employer. If all of your employees live and work remotely within the same state as your organization, the tax issues are easier, simpler, and more straightforward. But what if your organization is near a border with another state and you have employees working remotely from their homes in that state? What if you're an organization wanting to take advantage of remote work to tap into a broader talent pool across the country, recruiting people from different time zones? In these types of situations, the tax issues become a bit thornier. Even before remote working became more commonplace during the pandemic, the tax laws relating to remote work were rather confusing, with employers often incurring unanticipated tax liabilities from another state. But as employers start to rely on and utilize remote work models more and more, it's going to be imperative for them to develop some understanding of the various tax laws that may impact them and to be able to recognize when they need to seek out the specialized advice of a tax attorney. Under our constitutional system of government, every state has its own tax laws, and those laws vary considerably from state to state. There's actually very little uniformity amongst the state's tax laws. And an employee need only have minimal presence in a state to potentially become subject to that state's tax laws, or for that employee's employer to incur tax withholding responsibilities for work that employee performs in another state. The U.S. Constitution's Commerce Clause prohibits states from imposing their tax laws unless they are fairly apportioned from multi-state operations, and to protect business from taxes that discriminate against interstate commerce. The long and short of it is that states have a lot of discretion under the Constitution in determining the extent to which they want to tax employees physically working in their states. Next slide, please, Brandon. It's helpful to ask yourself two key questions. First, as an employer, are my employees' activities causing me to become subject to another state's tax laws? And it's also helpful to look at it from the employee's perspective. Based on my job duties and location, where am I subject to state income taxation, and how much should my employer be withholding from my paycheck? Next slide, please. This leads us to the issue of double taxation. There is case law precedent holding that state tax laws are not unconstitutional simply because they might result in an employee being taxed twice on the same income. So if you have employees working in other states remotely, you must determine what your tax withholding obligations are in each state. Next slide. And as an employer, you need to consider whether you might incur liabilities in three different situations. First, when your employee works remotely in another state, do you have a duty to start withholding that state's tax from the employee's salary rather than the state of the former work location? Second, do you have a duty to stop withholding taxes from the former work location when the employee begins working remotely? And three, are either of these duties different if performing the duty would either make the employee subject to double taxation or would result in the employee paying no state income tax anywhere. We obviously don't have time during this presentation to do a granular analysis of various tax hypotheticals that might arise with multi-state remote work operations. But the important point is that you need to recognize this is a complicated issue. So before permitting any sort of multi-state remote work, you need to consult with your tax attorneys to make sure you comply with all applicable tax laws and minimize your tax liabilities and obligations as much as desired. Next slide, please. So let's assume you've satisfactorily resolved these tax issues and you understand them. There are certain registration requirements you might have to comply with. When an employee begins working remotely in another state, some states require the employer to register as a foreign company with the Department of Revenue or some other government agency. These requirements vary state by state, so it's important to check the laws of each state and see what the reporting requirements are. If you have employees working remotely in another state, there may be penalties for failing to register with that state's Department of Revenue. Now, in the pandemic, several jurisdictions have waived these penalties, so it would be important to check whether they have done so in your case. And if there is a waiver in effect, make sure that you identify any sunset provision on that waiver. With that, I'm going to turn it back over to Brandon to discuss wage and hour issues.
All right, thanks, Jeff. Now, on top of state tax obligations, federal and state wage and hour laws can also create legal challenges for employers that permit remote work. We're only going to talk about federal wage and hour principles under the Fair Labor Standards Act, the FLSA, but be aware that your state might impose obligations over and above those set by the FLSA. The bottom line is that employers must pay remote workers in compliance with federal and state wage and hour laws, just like it must do so for employees who work on campus. So let's talk about basic principles under the FLSA. To begin with, the FLSA divides nearly all employees into two categories: exempt employees and non-exempt employees. Exempt employees are, as their name suggests, excluded from the FLSA's core guarantees of a minimum wage and overtime pay. When it comes to employees working remotely, the bigger concern comes from non-exempt employees, and I'll talk about those in just a second. But I do want to touch briefly on exempt employees. There are, the main thing to remember is that exempt employees roughly fall into one of 7 categories, which I've listed here. Those are the bona fide executive, the administrative, the professional, the highly compensated, the creative, the outside sales employee, and the computer worker exemptions. The FLSA and its regulations set forth specific tests for determining whether an employee falls into any of these categories. And for most of them, the amount of money that the employee makes is going to be determinative of whether or not they fall into an exempted category. But this isn't an FLSA specific webinar, and I have limited time, so I'm not going to go through each of those exemption tests. However, when you're examining your existing remote work policy or creating a new policy, it's a good idea to review and update your employees' position descriptions. And along with doing that, consult with your HR representatives and, if need be, your legal counsel to make sure that all your employees are properly classified as exempt and non-exempt. This is important because an employee that is incorrectly categorized as exempt can sue you under the FLSA for unpaid wages. And if the court finds that the erroneous categorization was willful, the employee can get triple its damages and recover their attorney's fees. This is obviously a situation you want to avoid. So the takeaway is evaluate all your classifications to make sure you're in good standing with each of your employees while you're conducting your policy review with respect to remote work. Now, as I mentioned a moment ago, the bigger concern in terms of wage and hour compliance, it comes from non-exempt employees. And this is because the FLSA grants two core guarantees to non-exempt employees. First, they are entitled to a federal minimum wage, and currently that minimum wage is $7.25 an hour. But be aware that your particular state's laws may increase that minimum wage above that $7.25 per hour floor. Now, in addition to the minimum wage guarantee, the FLSA also entitles non-exempt employees to overtime pay. The duty to pay overtime kicks in as soon as an employee works more than 40 hours in a given work week. And employers must pay overtime at a rate of 1.5 times the employee's normal hourly rate. So if an employee's normal hourly rate is higher than the $7.25 floor, that higher number is the one you must use to calculate the overtime rate. So what does this all mean in terms of remote working arrangements? When an employee works remotely, an employer obviously cannot monitor or enforce their working hours in the same way that it could when everybody is working on site or under the same roof. The inability to monitor your employees' working hours makes it absolutely critical that you set clear rules about what the working hours are, when employees can take breaks and for how long, what restrictions there are in terms of working overtime, and what the non-exempt employee is supposed to do if they receive an assignment or an email after working hours. Your rules must also clearly state how employees are supposed to report the work they perform outside of normal working hours or above 40 hours in a given work week. And your employees need to know to whom they need to report that information. Bear in mind that employers are permitted to require their employees to ask permission before working overtime. And those employees can even be disciplined for working overtime without permission. But at the same time, if an employee knows, if an employer knows or has reason to suspect that a non-exempt employee is working outside normal working hours, that employee becomes entitled to overtime compensation at the rate of 1.5 their normal hourly rate. So also be aware of the legal challenges that travel time can create. If an employer gives employees the right to work remotely full-time without qualifications or expectations about periodically returning to campus for meetings or other functions, that employee might be entitled to claim wages for their travel time. That issue is particularly fraught for hybrid work arrangements, that is, arrangements that allow employees to work remotely part of the time on a regular basis and part of the time in the office. If you permit a hybrid arrangement like that, you might end up paying for the employee's commuting time if they have to work part of the time at home and part of the time on campus. And finally, similar to the taxation issue, if you have employees that work in multiple states, you might be subject to the other states' labor employment laws, including varying wage and hour requirements. So given that possibility, it is critical that you know where your employees are working and set clear rules about what their working hours are and the other expectations that I've mentioned here. So with that, I'll turn it back over to Jeff.
Over the past decade or so, cybersecurity and data privacy have become more and more challenging to businesses and organizations. In tackling this problem, I think it's helpful to sort out the fiction from the reality. When we're talking about hacking, we're usually not talking about some shadowy figure in a hoodie hunched over his computer in a dark room like you see in the movies. Sophisticated hacking operations usually involve a warehouse of anonymous workers sitting at computer terminals overseas, sending out phishing emails or phishing text messages to unwary employees of businesses. These phishing emails come in varying levels of sophistication. Some have bad grammar and spelling, but some have excellent grammar. And they're not all being sent by Nigerian princes looking to help you make a fortune in diamond mines. Often, these senders of these emails will spoof the email accounts of other employees within the organization so that it appears to be a safe internal email communication. They often hook the employee's interest with something about their benefits, or perhaps even something more topical, such as COVID. The email includes a link to some document or case, or perhaps direction to another website. The employee clicks the link without carefully reviewing the email, and the link downloads some type of malware onto the employer's system, and now the hacker has access to the employer's data. Sometimes the hackers are just after confidential or sensitive information about a business's employees, customers, or clients, which they will then sell on the black market to people in the business of identity theft. What has become increasingly popular over the past few years is ransomware, where the hacker seizes control of the data, locks out the employer, and threatens to release the confidential information unless the employer pays a ransom. There are, of course, no guarantees that paying the ransom will be the end of it. Hackers don't just target large entities. Small businesses and organizations have also increasingly become the target of ransomware attacks. Schools, dentist office, law offices. And it's not a problem limited to private entities. Governmental entities have also been targeted, including large city governments. Next slide, please. When employers started moving more of their operations online, they increased their exposure to this type of risk. In the traditional office space, employers had more control over their employees' use of computers and email. But with remote work becoming increasingly prevalent, the risk of cyber attacks has also increased. This presents a significant challenge to employers contemplating new remote work policies as we come out of the pandemic. Cyber attacks increased dramatically during the pandemic as more businesses began working remotely to keep their operations running. Many had not yet had the opportunity to develop sound remote work policies, much less incorporate sound cybersecurity and data privacy disciplines into those policies. But for employers now contemplating new remote work policies, they need to do so now. Next slide, please. So what are the key components that you need to have in a cybersecurity and data privacy policy? Well, first and foremost, you need to train your employees on sound data security and privacy practices. The training needs to be active, engaging. You don't want to just rely on circulating a written policy that somebody may or may not read. That doesn't mean that written policies aren't critical, though. Your written policies need to set forth clear expectations for physical and electronic storage and transmission of information. So we're talking about password protection, securing hard copies of files in locked areas, limiting what employees may print and download, antivirus protection, secure remote access procedures, and adherence to other IT protocols. And in the event of some type of breach, there needs to be a process for immediate reporting of unauthorized access or disclosures or destruction of data. Your organization's IT, HR, and legal departments need to collaborate for data security and technical troubleshooting of these problems. Consider whether your organization has the resources it needs, and if it might be time to start scaling up those resources. Next slide, please. There are also other things you might consider tying into your remote work policies. How does progressive discipline tie into your remote work policy? How do you investigate an employee for possible carelessness with data? Toward this end, many employers have become implementing surveillance and employee monitoring practices. And this has become a big topic. Active monitoring might implicate employee privacy issues. And we're referring to their legal privacy issues as well as their personal expectations. Some employers also physically track an employee's location through their laptop, their tablet, or mobile device. If you choose to take this path, you need to consider what data you're collecting about your employees, what you're doing with that data, and also importantly, do your employees know that data is being collected? Some companies will essentially use sting operations as a training exercise where the IT department sends out mock phishing emails to see which employees bite and which ones delete the email and report it. If the employee fails the test, are they subject to discipline? Or do they simply need more training on the subject? These are the types of policy decisions you need to be making. Next slide, please. And to tie back into a point that Brandon made earlier today, it's important to use the written policies to adjust employee expectations. Employees might have objections to some of the more invasive practices, such as surveillance and monitoring. This brings to mind the old adage, an ounce of prevention is worth a pound of cure. You need to be proactive in clearly putting your employees on notice of these measures so that they can adjust their privacy expectations accordingly. Spell this out clearly in the policies. Don't just rely on fine print. Don't just rely on an employee authorizing IT to access their phones as part of the download process for a work app. It's important to keep your company safe, but it's also important to make sure that employees feel comfortable with these policies. Proactive and effective communication is the key. And with that, I will turn it back over to Nina Gupta.
Thank you, Jeff. So as our audience, I'm sure, is understanding, there's a whole lot to think about in these remote work arrangements that may not have occurred to a lot of people, like the tax issues and wage and hour issues. And as schools navigate all of those considerations, they also need to be mindful of something that might be more familiar in their everyday practice, and that's avoiding discrimination in remote work arrangements. The best way to do that is to keep some basic principles in mind as an employer. First, remote work should not change the terms and conditions of employment. It should not change performance expectations. Simply put, in-person workers and remote workers who are doing the same job should be held to the same standards, held to the same expectations, and evaluated under the same criteria. Second, clearly articulating those expectations and guardrails around remote work arrangements is key. Clearly set out those expectations on the front end so there is no gray area on the back end, such as expectations for availability, participation, etc. You might find, for instance, that your policy is better described as a flexible work policy rather than a remote work policy, for instance, if your policy prohibits workers from providing childcare during remote work hours. Also, make clear that the remote work arrangement can be modified at any time to meet your college's or school's operational needs. Long story short, remote work is a privilege, not a right, that is available but can also be removed. Develop that clear written policy surrounding remote work, and also have your employees sign an acknowledgement of receipt of that policy so they're aware of what their expectations are. If you have a clear and comprehensive written policy on the front end, you're better able to avoid and fend off any discrimination claims later. That being said, schools should keep in mind that anti-discrimination provisions apply with equal force for remote workers. There are laws that school districts, colleges, universities are already familiar with, such as Title VII, which prohibits discrimination on the basis of race and sex and other protected characteristics, Title IX, that impacts sexual harassment, the Americans with Disabilities Act, the Age Discrimination in Employment Act, the Equal Pay Act, just to name a few. There are, of course, others, and there may be state non-discrimination laws where you are as well. Schools need to be aware so of all of these various complex interplay between these laws, so they're not discriminating on the front end, even inadvertently. For instance, to use a silly example, you shouldn't say that only those employees under age 50 can work remotely because we don't believe older workers could effectively manage remote technology. Likewise, remote workers are also protected against discrimination in their work context. For example, racial or sexual harassment can take on different forms in a remote work setting. We've all, over the past year, heard about those horror stories where someone is in an online conference and they think they're having a private chat with a colleague and they're saying some very unkind things or inappropriate things, and come to find out that that chat was not so private after all, and all of the negative ramifications that come from something like that. We've heard stories about employees that may have sexually graphic or racially offensive and inflammatory objects in their background, or even an objectionable online background for a video conference. Someone sends an ageist or an ableist email. These are all the kinds of things that could give rise to complaints of discrimination in a remote work context. And your institution needs to be prepared to set standards for behavior and work through what those expectations are. And if you find yourself receiving a complaint, what a discrimination investigation might look like in a remote setting. How are you going to have access to your remote workers? What are their expectations for participation? How are you going to preserve investigative evidence? All of those kinds of considerations you should be thinking through now. Speaking of investigations, schools also need to think through what progressive discipline looks like in a remote work context. Not everything in the regular world is a firing offense, and likewise, not everything would warrant complete removal of a workplace arrangement. Consider how you'll not only monitor your remote employees' performance, but also how you're going to intervene with progressive discipline and any support that might be needed. Additionally, schools need to think about what remote work means for their disabled employees. Now, remote work has always been available as a reasonable accommodation under the Americans with Disabilities Act for disabled employees, provided that that arrangement would allow the employee to perform the essential functions of their job. And this goes back to something we said earlier. Take this opportunity to review your job descriptions and determine what really is essential so you can better articulate when remote work will or will not be a reasonable accommodation. Of course, given that so many jobs have been done remotely for the past year in an emergency context, schools can probably expect many more requests for remote work, with employees pointing to the last year of experience as evidence that a job can in fact be done remotely effectively. So schools need to be deliberate and thoughtful when they determine what is truly essential. Additionally, if you're offering remote work as an across-the-board opportunity for an entire job category, let's say you're okay with your entire accounting department working remotely because they can have access to their spreadsheets at home on their laptop just as easily as they would in their office on their computer, you may have disabled workers within that job function who need specialized equipment or other accommodations to access technology remotely. They may need specialized software. They may need specialized equipment. And those workers may have rights under the ADA to have those reasonable accommodations provided to them, even in a remote work setting. Also, you may find that your remote work policies have an unintentional disparate impact on your workforce. And we have seen this played out in reality this past year. We have seen how those workers who were deemed essential workers and had to keep coming to work in person tend to be overrepresented amongst racial minorities, overrepresented as women. So even a facially neutral remote work policy might have a disparate impact. That doesn't mean it's illegal. Of course, you want to make sure that you have done a good, thoughtful analysis of what job categories are going to be eligible for remote work and maintain documentation of that thinking so you're protected. But even if it's not illegal, it will likely have an impact on your workplace culture. And schools also need to be thoughtful about determining not only what job categories are going to be eligible, but cognizant of workplace morale issues that could arise as a result. So in conclusion, there are a lot of considerations as we move forward in what really is a brave new world that we're all learning together. One thing I think we can all reasonably expect is that remote work is here to stay in some form or fashion for the foreseeable future. And it's going to have wide-ranging impacts on how schools and colleges treat their workers and how we deliver our product and conduct our core businesses of teaching students. To make remote work successful, schools need to have to work in highly cross-functional ways, bringing together legal, HR, IT, tax departments. So all of these considerations that we've talked about for the last 45 minutes or so are thought through and addressed as proactively as possible. In addition, schools need to understand their organizational cultures and drive their organizational cultures to create successful remote work arrangements and maintain a good, healthy office culture. Meanwhile, since this is all still new and since we've gone through a year-long emergency that while it's hopefully getting better, it's still not quite over. We can reasonably expect that states and the federal government may be looking at statutes and laws and legislation that affect how we function in the future that surround remote work arrangements. In addition, we can also expect there to be litigation about what has happened over the past year in remote work, and that's going to influence how schools and colleges need to move forward as well. Working through these challenges sounds very difficult, and it is very difficult, but it's not impossible. And it also presents a real opportunity to reimagine our educational workspaces to leverage what has worked well as we all move forward. Now, our education team here at Nelson Mullins works closely with educational institutions on issues just like these, along with a myriad of other issues that you all face every single day. Brandon, if you could turn to the next slide. Please feel free to reach out to us if we can be of any further assistance. You have our emails, our phone numbers, and you can always visit our website to learn more about our team, and we're happy to answer any questions that you might have. Thank you so much for participating and attending today's webinar.